Hi, everyone. Thank you so much for joining us tonight. My name is Elise Rosemarin. I'm a Senior Vice President here at AKAM, and tonight we'll be speaking about tax abatements that are now tied to the prevailing wages. So this is very interesting and an emerging topic. So just to give you a quick background of who our panelists are tonight, I'd like to introduce you to the following. So we have Sarah Mannix, who is a partner at Clifton, Budd and Maria. Robert Sparer, who is also a partner with Clifton, Budd and DeMaria. And then we have our very own Meagan Mooney, who's a Vice President of Client Finance. So welcome, everyone. I'm just going to give you a brief background of who our panelists are, and then we'll get started. So Sarah Mannix is a partner with Clifton, Budd and DeMaria. She represents management and private sector collective bargaining negotiations and arbitrations. Sarah provides advice on labor and employee relation matters, including preventative advice and counseling. So welcome, Sarah. Thank you so much. Robert Sparer is a partner with Clifton, Budd DeMaria, as I mentioned before. He represents management and negotiations, litigation, and most other areas of labor and employment law. His clientele is predominantly employers, owners, and managers in the real estate industry. Welcome, Robert. Thank you.
Thank you for having
And
me.
last but certainly not least, we have our own Meagan, who is one of my faves here at AKAM, not to make others who are not my favorites, but she's great. And she has been in the business for over 30 years and is a wonderful resource to us all. So thank you so much, and let's get started. So tonight what we're going to be doing is obviously going to be discussing this new law. We've received a lot of questions prior to starting this tonight. So we'll start with the questions that we received thus far. And as usual, we'll talk about the topics and of course invite you to put any questions that you have in the Q&A box. There will be a Q&A at the end of tonight, but we welcome during this conversation as well, because we of course want to answer questions as they come through. And if there are any questions that you have that you'd like to ask any one of us, please feel free to reach out to us after, and we'll get back to you. All of our information will be provided later this evening. All right, so thank you so much. So can you guys give me a little bit of a background as far as what's going on with this new law, and just, share the information that we have thus far?
Sure. So we're here today to talk about what was Senate Bill S6350A, which was signed earlier this summer. And this applies to New York City co-ops and condominiums who have a tax abatement under 467A. So right off the bat, if you or the building that you're thinking about does not have this sort of tax abatement, this does not apply. But for any building that has this 467A tax abatement, this new bill requires that recipients pay the building service workers in their building the quote unquote prevailing wage. There's a couple of exemptions here. So even if your building or your unit does have a 467A tax abatement, you might be exempt from this obligation to pay the prevailing wage if certain conditions are met. And those exceptions are in buildings where the average unit assessment is less than or equal to $60,000, or buildings where the average assessed unit value is more than $60,000 but less than $100,000, and you have less than 30 dwelling units in the building. So there's limited exceptions here. And if you qualify for the 467A tax abatement, you're required to pay the prevailing wage, as I said before. So what does that actually mean? The prevailing wage is a wage schedule that applies to different classifications of employees. And here we're talking about building service workers. The definition of a building service worker is in the bill. The general advice, I guess, would be if someone works in a building, they're likely a building service worker. But a building service employee is defined in the bill to include, but is not limited to, a watchman, guard, doorman, building cleaner, porter, handyman, janitor, gardener, groundskeeper, elevator operator, and starter, and window cleaner, but does not include persons regularly scheduled to work fewer than 8 hours per week in the building. So the prevailing wage schedule is mostly the same for most of the categories that I just listed, the building service wage schedule. If someone were a window cleaner, a slightly different prevailing wage would apply to that person. If someone is an armed guard, a slightly different wage might apply to that person. So the prevailing wage is set by the city, available online, but it does slightly depend on the job classification that we're talking about. So within that, there is the wage component, and those wages are set, the hourly amount, whatever that is. There's also a scale up for new hires under the prevailing wage. So when someone is hired into a building service role, they are set at 75% of whatever the appropriate wage rate is at the beginning of their employment. Then they're bumped up to 85% after a certain time period. And then after 42 months of employment, they will be receiving the 100% rate. And going along with that step up in wages, there is a benefits component as well. At the beginning of someone's employment as a new hire, there is no obligation to pay this supplemental benefit rate. And that at month 3 of someone's employment, someone will be required to get 75% of the supplemental benefit rate. Then they'll move up to 85% of that rate when they move up to 85% of the wage rate. And then they'll be at 100% at some other point in time. This is a lot of numbers and percentages, but it scales up very similarly to the 32BJ union contract, if you are familiar with that at all. And it's a very defined schedule online. But the important part is it has a wage component and it has an additional benefits component. If your employees if you're required to pay the prevailing wage and the employees in your building are already covered by a collective bargaining agreement, such as the 32BJ agreement, you are probably in compliance with this already. Although I should say right now that none of this is legal advice, and for specific questions on your buildings or specific tax questions, do I have this tax abatement? Consult with your specific building professionals about what applies to you, what you're doing right now, and specific professional advice for each building. So that was a lengthy overview, but that is the general overview of the bill, and happy to take other questions.
Can I ask how this came about? Do you have any idea what spurred it? Yeah, Robert.
I can tell you, since I spoke to the guy that wrote it. So this bill was, let me back up. So a 467A tax abatement is something that's available to co-ops and condos, and you find out on your tax bill. It wasn't tied into wage rates or prevailing wage or the union. Federal law doesn't let the state say you have to have a union contract. So local 32BJ has systematically over the course of several years, decade or so, petitioned the government, city government, to add things. So there are laws that require building service workers to go with the new employer. It doesn't happen in condos and co-ops so much, but like when it's developed, before it's sold out, the employees have to go with it. When the commercial building changes hands or a residential apartment building, the rental building changes hands, the employees have to go with it. It makes it easier to organize. Local 32BJ was hitting a real roadblock with respect to co-ops and condos, because if you're paying $20 an hour and your benefit load is $10 an hour, you're all in for about $30 an hour. There are taxes and whatnot and all the rest. But you're at will employees. You can fire anybody at any reason, anytime, make staffing changes, all the normal things that you do. If you're under a union contract, though, right now, in a residential building, anybody that isn't a handy person or a superintendent or resident manager is called another, and they get $26 and 45.08 an hour. That's the wage rate once they're all in. The benefit load adds right now $13.71 an hour to the cost. So you're talking about people that are opening your doors and cleaning your floors. I'm not denigrating them in the least, but they cost you all in with all the benefits and the time off about $100,000 a year if you're under the 32BJ contract. So, instead of $30, you're paying 47 or so, $43 an hour for these building service workers. So it was hard for 32BJ to organize. So they got the governor to sign this bill, which has been on the prior governor's desk and pocket vetoed, I think twice, because 32BJ thinks that this will make it easier for co-ops and condos to get organized where they're not a union building. When I say a union building in this context, I mean a 32BJ building. So they got this passed, the governor signed it, and I, just as an aside, I have to point out, in this day and age, does the bill really say doormen and handy men? Come on, the contract doesn't even say that, I think. At least the Bronx contract doesn't, because we took it out. But the reality is that's what this is. This is a means for the union 32BJ to organize. It's confounding because there are other unions and they're not as expensive as 32BJ. Now we run into run headlong into a clash. You've got a statute that says you've got to do this, and you've got a contract that says you don't have to do that. But most contracts don't say you can't do the higher rate stuff. So what it means, on top of all your budgeting, if you've got a 32BJ contract, like Sarah said, you're pretty much in like Flint. You're in good shape. And that was probably a little bit showing my age. Anyway, you're pretty good. If you've got a 670 contract, the local 2 contracts, any of the other contracts, other union contracts, you may be paying too little. And now you got to deal with it. And how do you deal with it? You have to go to the bargaining table. 1, you have to budget for it. And 2, you got to go back to the bargaining table. How do you budget for it? Typical fashion. You're looking at a statute that's a little bit of a pigsty. The city does the taxes. The city has a fiscal year of July 1. It's a state law. The law says that the prevailing wage has to be paid starting in fiscal year 2022. Well, that's the state fiscal year. That's April 1. But it doesn't say as of April 1. So you got April 1 as the earliest date. You got July 1 as a possible date. And somebody has to tell us when it is. What we're hearing is it might be July 1. That sounds like the way it's going. It lines up with everything else. But as of this moment, you got to go with the worst case scenario so you're not caught out with an unbudgeted for expense. So prudence says, and there are divergent opinions, and I'm going to echo Sarah again. You got to talk to your building professionals. This is not written in stone. It's not written in anything, is the bottom line. So it's, talking heads like me saying, this is what I think. I'm not the governor. I'm not the mayor. I don't do any of this. April 1 to July 1 is the likely range, and budget for April 1. If you don't spend the money, that's nice, but it's a reasonable budget approach until we know for sure that it's April 1 or July 1. Go conservative. 32. Once you budgeted, you got to talk. If you're not 32BJ, you got to talk to your other unions, whatever union represents it, because under the federal labor law, you're not allowed to make unilateral changes, and this would be a unilateral change. Unilateral change is a change in terms and conditions of employment that you have not bargained for. You can look at your contract. This is why you look at your professionals, because your union contract might actually give you the leeway to do this. Ultimately, you have to comply with the law. But here's what we're seeing a bit. We represent a couple 100,000, I don't know how many, I've never counted them. Let's say 1,000 buildings in the city of New York. It's pretty close. I've got clients that are looking at the numbers and saying, we're giving up our abatement because our abatement, the delta between our abatement and the cost is $200,000 a year. There's one of my clients. They're like, we're done.
Can I
It's
ask
too
you,
expensive.
so going back to that, can you go back to the cause and effect of the abatement? I think not everyone, I think some
Sure.
people were joining late. And one thing just again to touch back on is, does this apply for part-time staff members? And if so, I believe you said there was a limited amount of hours. I think you said 8 hours or less. But
Less-
can you just maybe touch upon those two things for people who were joining us late?
Sure. So I'm a labor lawyer, as is Sarah. The tax questions are really, you need a particular advice. But the general concept is, at some point, somebody applied for an abatement under 467A of the real property tax law and got it. Then the law, then this obligation applies. In condos, I think the way it works is a unit owner applies, but the condo has to be involved. I think on a co-op, the whole co-op does it. And there are a lot of exceptions. And again, I'm not this is not my area, but what I'm told is, if it's owned by an LLC, the unit, it's not eligible for the abatement under 467A. There are a lot of abatements. The J51, a city law concept, as I understand it, not a state law concept. So it's a different thing. There's 421A of the real property tax law, which is another sort of not another sort, it is another abatement. And it has, since like 2000 something, ought something, 07, 08, 09, something like that. Not 07, 8, 09. It imposes a prevailing wage obligation. If you get city funds, you may have a prevailing wage obligation. But question is abatements. You have to apply for them. Now, it could be a sponsor applied for it when they built the building, could be a conversion, affordable New York is I think part of the 421A program. So that's where you go to your tax professional who's going to say, you have a X abatement because of this application way back when. You'll see, and I've seen, Sarah and I unwound some ugliness where condo had a 421A tax abatement and they had an obligation to pay prevailing wage. They did not. It was not good. They had a lot of liability, but they had gotten that abatement. That is a factual thing. And so you find out you have the abatement. I've seen some tax reports where it says, right on it that it, the 467A abatement or whatever. I don't remember what the abatement was. So there are all those things. It's a fact if you have an abatement. Prevailing wage. Sarah talked about the two biggies. There's a third bucket of prevailing wage. You got the salary, you got the benefits. And when I say benefits, I'm talking about like bona fide employee benefits, health, legal, training funds. These are the 32 BJ things. Pension, 401k, profit sharing. Those are bona fide benefits. But there's also the ancillary benefits, time off. So on top of all the normal stuff that we just talked about, you also have to give the union contract holidays, vacations, overtime after 8 hours, other things too. It's just kind of 3 buckets. And you got 3 distinct buckets. I'm holding up 10 fingers. Good. You got 3 distinct buckets. They don't spill back and forth. So if you overpay on benefits, you don't get it on the wages. Overpay on wages, you can kind of cut off the extra wages and throw it into supplemental benefits. Supplemental benefits are for all employees. The 32BJ concept is you get those 5 benefit fund contributions and participate in them if you are a full-time employee, 40 hours, or more accurately, pension and SRSP, the 401k/profit sharing. So if you work more than 20 hours in a week after a year of service for the pension, 2 years for the SRSP, 20, and it's a week-by-week analysis. For the health, legal, and training funds, it's if you work more than 2 days a week. It's not 2 full days. It's not even 2 hours a day. It's 2 days. You work more than 2 days. So if you have a part-timer that comes in Saturday, Sunday, and you'll come in on Wednesday to help with the trash, health, legal, training. If it's more than 20 hours, pension and supplemental benefits. That's the union contract. The prevailing wage just puts a dollar figure on it. You must pay $13.71 an hour. That's the current number for a fully, so an employee who's been there for more than 2 years. Some can be shorter than that, but we'll use that as our guidepost here, which is why you have to talk then to you, not only to your lawyer and accounting professionals, you need to talk to your property management professional to figure out where they fit in too. It's a big mess. You're paying $13.71 an hour unless the person works less than 8 hours a week. Right? So long-winded way of saying part-timers are covered. They get the salary, they get the $13.71, they get the ancillary benefits, which are a pigsty for somebody who's part-time, but they get all three of them, just on an hourly basis, except for the ancillary stuff, which is.
Got it. And then does this apply to buildings that, say a condo is under J51 as an example until 2025? Do they have to comply with the prevailing wages now, or are they exempt until it expires?
Well, the J51 program looks like a city program. I have not seen it in the law exempting it. It's a more tax question. With her, I'm relating what I've heard, that if you have certain exemptions, and maybe J51 is one of them, you can't get a 467A. If you've got a 467A abatement and a J51, that's where you got to go and dig in and see if there's an exemption, and hope that the city issues some regulations that will be helpful so you understand what your obligations are. I would put that one as a question mark at the moment, but it's very likely you can't have both.
Okay. And then similarly to kind of, I guess, people understanding the parameters, say someone lives in a building that has a guard at the front door 24/7 rather than a doorman. The building pays a third-party security firm for that service. Since the guards are not employees, does the building still have to worry about their wage?
Yes, they have to worry about it. And they have to worry about it in two contexts. You remember Sarah was talking about guards get a certain rate and yeah. So the comptroller of the city of New York enforces the prevailing wage laws in New York City, obviously. And they take the approach that a security officer, guard, security, whatever it is, watch person, is security. I'm putting them as security if they patrol, enforce rules, and don't do anything else. They might, they might be able to call people up and say, so and so's here. That's their role. They don't take packages. They don't open doors. They don't call taxis. They don't fingerprint doors. And it's not a question of what they're supposed to do. It's a question of what they do. So, one, these workers must be paid the prevailing wage if it's a prevailing wage building. So it's the obligation of the beneficiary of the abatement or exemption to ensure that the employees are paid correctly. And it's their exposure and liability for compliance. And most contractors aren't about to step up and say, oh yeah, well, we didn't know, sorry, we'll pay for that. They don't like to do that. So you got to be careful there. So prevailing wage, yes, it's the beneficiary's obligation, the co-op or the condo. But if they start doing extra stuff, they go from the low rate to the high rate, and it's really expensive at that point. And it's very problematic. And Sarah, I think, had to unwind one of those, which, by the way, was written by a big chapter. Sarah didn't have to write it, the client did.
So in
Not,
essence,
no one was happy.
oh man, it sounds hard. Yeah, I was going to say, so in essence, it does include staffing companies, this law.
Yes,
Yeah.
but the building should be careful and ensure that the staffing company is doing what they're supposed to be doing. So someone can certify under, that the prevailing wage is being paid. So you would want to dig into that with the staffing company. And as Rob said, staffing companies might not be super forthcoming about needing to pay people more unexpectedly. So that should be worked out before there's an issue, before anyone's signing their name to a paper certifying that they're being paid the prevailing wage.
That's good advice. Does the law apply if a staff member is either salaried or working part-time? So you mentioned this, I think people are still wanting to really get to the nitty-gritty about the hours that I think this applies to.
So,
Go ahead, Sarah.
so part-time, yes. I mean, it would not apply if someone is working less than 8 hours a week in a building. So that's probably a limited occurrence. Otherwise, this would apply to part-time employees. If if you have a 467A tax abatement and you're required to pay the prevailing wage, your part-timers will be you should pay them the prevailing wage as well.
Okay.
If I may, if you're talking about a salaried person in the building service industry, the only person that should conceivably be salaried exempt is the resident manager or superintendent. And so you do have that situation, but the law does not, there's a quirk in the law. It doesn't have a superintendent rate and a resident manager rate. The comptroller uses the handy person rate, which is an hourly rate. And it can be a real catch-22 because you don't keep track of a salaried exempt employee's hours, but the law does kind of require it. The upside is, Sarah mentioned the two buckets, and I added the third, the supplemental benefit rate bucket. For somebody, remember I said bona fide benefits. The value of that apartment, and there's a formula to figure it all out, is a supplemental benefit. So that 1371, if you got a resident handy person, resident superintendent, probably eats up the entire thing when you talk about the value of the apartment, the utilities and things like that. Unfortunately, it probably exceeds it, but it doesn't flow back into the other side. The other piece is a superintendent or resident manager is probably going to be paid substantially above the $29 and change the handy person gets paid. So you're probably going to be okay. Probably is a risky thing. Talk to your professionals. Make sure that you're right. And you may have to start looking at the superintendent resident manager's hours so you can verify that you're in compliance.
All right, so I know this was briefly touched upon exactly, but what exactly is a 467A, I can't speak today, abatement?
Sorry, can you say that again?
Sure. I don't know if you understood what I was saying because I don't understand it. What exactly is a 467A abatement?
Okay, it's an abatement of your real estate taxes based on an application that complies with, this is a little bit circular, I'm sorry, again, not my area, but if you qualify and you apply and it gets approved, there's an abatement on the real estate taxes, either for the building, I think it's the building as a whole or the unit if it's a condominium. And it's just a tax benefit like the STAR program for seniors and things like that. And it reduces the real estate taxes.
And it's anything else to say on that? Sorry.
No, Sarah, were you going to say
Oh,
something?
I was just going to say that this applies for residential real property held in the form of a co-op or a condo in a city having a population of over 1 million. So limited, New York City obviously fulfills that, but residential real property in a co-op or a condo.
We kind of refer to it as a condo co-op abatement. Generally, it comes off the co-op's tax bill and the city gives us who the individuals are that get the credit. And most people typically get it in June. With the condo, it comes off your bill directly. So that's really the benefits we're talking about.
Okay, so going back to the building value, because we were talking about the live-in super before, how should a building value the super or RM's apartment? Market value, anything else?
The way it's done is the cost of the unit is no more, the credit is no more than the value of prevailing rentals in the locality for comparable dwelling units. Not very helpful, but you look around, you see what the value is. Of course, if you're on a condo or a co-op, you may have some rental units, but you may not. So then you do a little bit broader look and you try to figure it out, be reasonable, save your paperwork, and be prepared to show it to the comptroller if there's an audit.
Great. Going back to 467A, how do you qualify for that?
It's a good question, but it's a tax question. Don't know. I can tell you, you don't.
Those are
qualify.
generally, those
Go
are
ahead.
generally the primary residents.
Mhm.
You have to live in the unit you're claiming, no more than 3 units, those kind of rules.
It can't be, I believe it can't be held in like a corporate form.
Yeah, it can't be an LLC. You will not qualify. It can be a trust, but the trust has to be in the person who receives the benefits name.
So do all co-ops qualify automatically or?
No, you have to apply.
Yeah.
All right, going back to employee hours. What if the weekly hours total of the employees, sometimes 8 hours, sometimes it's less? How do you make it that?
Sarah, do you have that?
If it's a
Regular.
fluctuating work week,
No, actually, I got it. Sorry. Regularly scheduled to work fewer than 8 hours per week. Regularly scheduled. What is
So the flexibility factor doesn't apply?
that? You'd look at it, you'd have to have a regular schedule for this person that's under 8 hours.
Got it. Is a non-32 BJ building, in a non-32 BJ building, do the collectively bargained benefits count toward meeting the prevailing wage minimum?
Yes. The supplemental benefit rate, not the prevailing wage. You know, you got a prevailing salary, not the prevailing wage as a whole. It's only that one component, the supplemental benefit. But yeah, it does. You got a credit.
And And to clarify, the supplemental benefit includes potentially, if you're living super, than that, but health, pension, 401k, vacation, holidays, overtime, over 8 hours, etc.
Yeah, supplemental benefits are not the overtime, not the holidays, not the vacation, not the sick leave. It is things like health insurance, vision, life insurance. If you've got an apartment, that's considered. If you give them a parking spot, that's probably considered utilities. If you're reaching in, if the board is reaching into its pocket to pay for a benefit, that'll probably do it. If you give them a cell phone, I'd be careful about that. But the overtime, the vacation, the sick, the holidays, those are clinic days, personal days. Those are the third bucket of ancillary benefits. They don't credit the $13.71 an hour.
What about a bonus?
Bonus? That's a good question. Depends upon how you do it. If it says, here is money to make up the difference, it's not a bonus. An additional bonus is bonuses are generally considered wages. So I don't know the answer exactly, but we'd have to look into it. It would probably go into the wage pool, not into the supplemental benefit.
And the same with 401k or?
401k is a benefit that if you think about classic employee benefits, health, legal, health fund, retirement fund, life insurance, those sorts of things, those are the classics. The apartment is something that's a little out of the ordinary, for our industry, but that's the way it works.
Got it. All right. So we have a threefold question. Are you ready? It also might be too particular. So if it is, we'll answer this offline, but here we go. So the difference between the supplemental benefit we provide today, which is like health insurance, et cetera, and the new rate for supplemental benefits is about $20,000. So given that, do they pay the difference as part of a regular salary and also continue to pay health insurance? That's one question.
Okay.
You can say yes.
Yes.
Two, or do they pay them the full supplemental benefit and say they're on their own for health insurance? That's a not, no?
I would say watch out, because the Affordable Care Act might come into play and you might have to provide the benefits. So I wouldn't do that. And I wouldn't do that for several reasons. One, if you provide a benefit it's not taxable to the employee, it's not taxable to the employer. There's no Social Security, there's no Medicare, it's cheaper. Two, the New York State and New York City prevailing wage laws suggest that the supplemental benefit rate, they suggest it by saying so, are paid for 40 hours, perfectly legal. And they say that's all, suggesting that it's not calculated in the regular rate of pay for calculation of overtime. The federal law doesn't say that. Consequently, the calculation gets more complex, but, and I won't get into that, but if you've got more supplemental benefit money each than you would by paying for the health insurance, the regular rate of pay goes up and your overtime rate goes up. And it's complex. But it's more costly to cash out than to give them the benefits.
Okay, so are there penalties though for not paying the full supplemental benefit?
Penalties? Yeah, so you pay what you didn't pay, you pay interest, and you jeopardize your abatement.
Okay, so got it. All right, here's another personal question. We are a signatory to a union contract that is not 32BJ. The law is pretty much busting the union contract and compelling them and the workers to adjust the 32BJ contract. Without any further negotiation or give and take that is at the heart of labor negotiations, has anyone ever challenged this law?
The law has been in effect for about 2 months. I haven't seen any challenges to it. However, when New York State raised the minimum wage, it affected some unions. It's the police power of the state. I don't think it infringes on collective bargaining. What it does is it puts a burden on the employer to go to the table. Does it bust the smaller unions? I don't think so. I think it's exactly the opposite, because what it does is it says you got to raise their wage rate. You're going to give them more benefits. Makes that union look stronger because it can say, look what we got for you. It's cheaper and more efficient for the employer. Generally, 32BJ is, is it the 400-pound gorilla or the 800-pound gorilla? I forget. They're pretty big, they're pretty powerful, and they can be unreasonable. Their contract is more restrictive than a local 670 contract or any other union contract. I've seen some ancillary unions that have pretty much 32BJ contracts, but the non-economic terms that this law does not require you to adopt can be onerous. I've got collective bargaining agreements that say you can't fire any employee without a just and reasonable basis or something like that. That's a far cry from just cause. Got some that say that everybody is subject to an arbitrary standard. I've got some that say nothing about it. The cost is got to come up, but those non-economic contractual obligations remain. So from the board's perspectives, they should, I would say, protect their contract. There are other issues. Their jurisdictional disputes between unions are frowned upon, and in this industry, they tend to be the unions tend to be fairly respectful of each other, and they don't go and raid each other. So, Local 2 isn't going to get, the heavy hand of 32BJ on its shoulder. Usually, BJ will leave them alone so that they don't get raided back. But you just go to the table and say, I now have, $4 an hour on wages that I have to implement, and I've got $8 in benefits. Where do you want to put the benefits? And you're going to put it in their pension, or you're going to put it better than a defined benefit fund, do a defined contribution fund like an annuity fund or a 401k. Put the money there. The guys and women who work for you will enjoy the benefit of it. It's what union is going to say no, because you have to comply with the law. If they do say no, you've bargained, you've got no choice. you're gonna have to implement it, and you'll say to them, I'm gonna do this. And if you say no, then I'm gonna have to pay them the money, and you can explain to them why they all of a sudden got a, 70% wage increase.
Got it. Regarding overtime,
Mhm.
does that also go into factors? Sorry. Like when, would you have to pay 1.5 times the prevailing wage, or can it be a lesser amount? Excuse my noise here.
No,
He
it's
wants to get prevailing wage. No, I'm kidding.
So the way it works, if it's bona fide benefits, so you're not paying any supplemental benefit rate money, you just look at the salary. It's time and a half. If you are paying money to make up the difference between the bona fide benefit actual cost and the 1371 now, I think it goes up to 1426. It does, because I just looked on January 1. So whatever that delta is, let's say it's $4 an hour, you're going to be cutting them $4 an hour, and it should be accounted for appropriately in the pay stub. So, if the person is just working an extra hour and isn't going to hit 40 hours in the week, you have to pay overtime. You just stick with the state law because that's the way it would work, and you'd pay overtime time and a half at $26.45 a week right now. Bear in mind that number is going to go up April 21st, or retroactive to April 21st, once 32BJ negotiates a new apartment building agreement next year. This contract is the prevailing wage is based exclusively on the 32BJ Manhattan contract. So when it goes up, when the contract goes up, this goes up. So complexity is, you got that $4. What happens when the person works more than 40 hours in a work week? You've now got a blended rate. And I'm going to do this. You got to do it very carefully. Meagan is probably the right, well, no, payroll people are the right people to do this. Figure it out exactly. But essentially, you're going to take how many hours a person worked, how much they got paid, divide it by the number of hours, figure out how many hours over 40, and give them half time of whatever that regular rate is for all hours over 40. And so it gets blended into the whole regular rate, these excess dollars that go for the supplemental benefit rate, and it's a pigsty. But no, you don't go down. State and federal law say for all hours over 40, you must pay time and a half of the regular rate. Failure to do so opens you up to double damages. Well, the principal double, attorney's fees, and then of course your defense costs. So you get to pay your attorney's fees and the other side's attorney's fees. And an interesting quirk of New York law, it's not interesting. Wages, non-payment of wages is not an insurable loss. So if you don't pay them the right number, the insurance company is not going to pay it. They might pay the damages, they might pay the extra stuff, maybe, but probably not. Might give you a defense cost. So it's really the co-ops and condos budget hanging out there for mistakes.
We've gotten this question twice now. So how does this differ, for a building applying for the abatement versus an individual unit owner doing so?
So my understanding, Sarah actually does talk. I'm the managing partner. She's not. I'm used to talking over her. I apologize, but I'm also the old guy. So the way it works is it talks about building. It's a building that receives the abatement. Got to get some clarity, but I would think that the way it's going to work out is you got a 400 unit condominium and one unit owner gets the abatement and isn't otherwise exempt. I'll bet you that the abatement is not worth it. Long and the short of it is it's the building, not the unit. So the single abatement could trigger the prevailing wage for the entire building. On a co-op, obviously, it's a building that's getting the abatement. So,
And people may want to consider also, there may be other consequences of losing employees to buildings paying a prevailing wage. So something to consider in the mix.
Sure. Okay, so if a rent, I believe that we covered this, but again, to clarify, so a rent-free apartment, most likely this means a live-in super, is part of the compensation, and that value can be included in the prevailing wage.
Okay, let me just back up. The apartment is not part of the compensation. The apartment is provided incident to employment in the benefit of the employer. If it was part of the compensation, it would be taxed. Now, the value does get reported, I think. Another tax question, but I think it is reported, which might yield some help and guidance in determining the value of the apartment. But yes, the value of the apartment does offset the supplemental benefit rate, which is not inconsistent with the law, since you don't pay taxes, the employee doesn't pay taxes on the health insurance, usually. There are exceptions. That answer the question? I think I went off on a
So
tangent.
some people had I can't speak at all today. They had subsequent questions, supplement and subsequent. So I think they want to understand, is the prevailing rate the sum of the hourly rate and the supplemental benefits, or are they two different things?
3 buckets. Salary, 26.4508 an hour right now for an other. Supplemental benefit right now, $13.71 once they're all the way in. Ancillary benefits, sick, vacation, holidays, overtime after 8 hours. 3 buckets. Interesting point. If you read the prevailing wage schedule, it specifies sick benefits that violate state and city law. They don't provide enough benefit for the first year of employment.
Got
So if
it.
you follow the controller's prevailing wage schedule on sick, you've violated city law and state law. So don't do that. 1 hour of sick leave for every 30 hours of work.
So
Starting
for
right away.
supers, how does that work for them specifically? And since the super's apartment counts against ancillary benefits, can you take away sick time, vacation, and have the super buy them back?
Nope.
And and also, can overtime work? How does that work for overtime?
So the value of the apartment could consume the entire supplemental benefit rate. Take it right out of the equation. You don't get to take the excess and put it in a different pot. Got 3 different buckets. They're distinct. Money, it doesn't flow one to the other. So how would the overtime work? If the superintendent is non-exempt, meaning you have to pay overtime, and he or she has gotten all the supplemental benefit paid for by virtue of the apartment, you're just looking at the employee's rate of pay. Now, you remember I said there's no superintendent's rate, so they use the handy person rate. That's the floor. Overtime is not based on some artificial floor. It's based on the person's regular rate of pay. So a superintendent that worked 50 hours that is not overtime exempt and is salaried at $1,000. Now that wouldn't be a superintendent. $2,000 an hour. He's not a lawyer. Come on, a week. You do some math and figure it all out. If there was supplemental benefit money, you take a look at how much you paid. You throw in the extra from the supplemental benefit rate, divide by the number of hours, come up with a regular rate, pay half time for the extra hours. And if they're salaried, non-exempt, it gets more complex, and my brain is not working well enough to explain it.
So for building employees that receive a W-2, is the employer's portion of the federal tax payroll obligation considered any type of benefit for purposes of prevailing wage, or no?
No. That's a short answer. No, it's not.
The longer answer, only a little bit. If the employee pays, the employer gets no benefit. So if you've got health insurance where the employer pays $500 and the employee pays $300, you get a credit of $500 a month. 500 times 12, 6,000 divided by 2080, which is a 40-hour work week. There's your supplemental benefit number. And I'm not doing the math in my head because I would be wrong.
I will give you this math question after, because this is about adding and subtracting prevailing wage calculations. So we'll answer this one after because this one seems tough. But what about a super that is contracted for 50-hour work week? Should the blended hourly wage need to meet prevailing? That might be another one. That's
Yeah.
Matt.
So the answer is, number one, when I started in the last century, started practicing law in the last century, the hottest area of litigation was discrimination in the employment field. Right now, it's wage and hour. Usually restaurants. Building services got a certain cachet as well. So you got to be very careful. If you're paying them for 50 hours, you got to make sure at that point they're not exempt. You're going to take 50 and you're actually going to say, well, it's 10 hours extra. So we're going to look at 55, divide that and make sure that hourly rate is at least the handy person's rate, which is at the moment $29.08 an hour. If it's not, you're paying below prevailing wage rate. You're above minimum wage rate by a long shot, but you got to take a look at it. And this goes back to, you got to figure the regular rate of pay. You're allowed to do what you just described. You got to be really careful about it. And if he works over the 50, there's extra compensation if they're not exempt. If they're exempt, overtime exempt, and superintendents, resident managers could be, they don't get their hands dirty and they run a big staff. Yeah, they're probably overtime exempt. But you do have to be careful with it. The 50 hours, you got to unwind it, break it down to a regular rate and take it from there. It's rather complex.
Sounds it. This actually is also an interesting question. If benefits are upgraded to 32 BJ level, but some staff choose to not enroll, will the co-op be required to provide additional make-whole compensations to the employees?
Sarah?
Yes, and that, so just to clarify again, every building service worker that you have now that you'll hire in the future, they get paid an hourly wage rate for their time, right? You're paid out by the hour, your hourly wage, it calculates your overtime. When we're talking about the prevailing wage and the $13.71 per hour in addition, that is the supplemental benefit rate. So any sort of, so if you're offering a health insurance plan and most of your staff accepts, and that plan is at the 32 BJ rate, and there's two people, let's say, that say, nope, my wife has health insurance, my spouse has health insurance, I don't need your plan, I'm not interested. Those two people would still need to receive the appropriate supplemental benefit rate. So that is $13.71 per hour up to 40 hours in a week. Everybody else who is on the health insurance plan provided by the employer, that obligation to them would be covered by the employer, if it's equivalent to the 32 BJ rates, would be covered by the health insurance that's provided. And for the two people that did not need that health insurance, that you would have to provide them with the supplemental benefit rate. And maybe that's a cash payment of $13.71 per hour up to 40 hours in a week. Maybe we'll take that amount and put it into a 401k for you. Whatever it is, if you have a union contract, that would simplify this question, certainly. But those people are still entitled to the prevailing wage, hourly wage, plus the supplemental benefit. And then again, everybody would be entitled to that paid time off in the vacation schedule.
And here is another caveat. Under those circumstances, I don't think it's ever really come to head, but you have to talk to your professional about whether giving employees the option, which that would be if they take the supplemental benefit rate as a cash, it may be a cash out option that may affect the deductibility or the taxability of the benefit to the other people. So you should look into that and get an opinion if you're going that route. Sarah's suggestion, maybe putting it in a 401k is something you'd have to look at, but the employees would not be getting the money. The touchstone is actual payment by the employer. If the employee gets the benefit and you actually pay for it, bona fide, no shenanigans. And I know of someone who went to jail because they concocted a crazy prevailing wage workaround, which didn't work. You only get credit for what you actually pay for, and it has to be bona fide. So you can't, you can't create an insurance company for a variety of reasons, but the employer couldn't create a insurance company that gets paid X amount and pays no benefits. So the employees are all enrolled in a sham, but the employer or the insurance companies, quote unquote, is making all sorts of profits, and it happens to flow to usually the owner of the employer. That was the scheme. So you got to be careful about that. Actual payment.
Yes, for sure. All right, so we're going to be wrapping up here. So we invite any other last remaining questions, please let us know. And again, if we don't get to them, we will definitely respond back after this. So the regulations that we have offer healthcare, for example, in our benefits, and they show this as an expense. If their super doesn't take the plan and has their, if their super doesn't take their plan and has their own alternative, why would they put it in their budget as an expense? Should it be removed?
Under those circumstances, it should be moved. If there is insufficient other bona fide benefits to meet the prevailing wage supplemental benefit rate. If it's just excess, and again, we're talking about it, he's got a penthouse apartment on Central Park West, I'm going to venture a guess that will cover the $13.71 an hour. Then it could be removed from the budget, unless he has the opportunity to opt back in at any time. If that's the case, it's a judgment call, not a legal, not a labor law question, it's budgeting and accounting question of whether you want to account for that potential.
Right, and I guess we will finish up with this question. And again, please, if you have any questions after this, please feel free to email any one of us and we'll get back to you. All right, we'll do two more because got a few more coming in. All right, what are the criteria, if any, to define their only employee as full-time live-in super? What are the criteria, if any, to define our only employee as full-time live-in super exempt salaried employee?
All right, so full-time doesn't matter. If you're salary exempt, you need to receive a salary of sufficient amount to meet the state threshold. The federal threshold is still low, somewhere in the $50,000 range. They need to, that's the start. If it's a live-in superintendent, the only employee, you don't have to worry about the state law because of the building service wage order that exempts what are called janitors, and each building can have one janitor. So setting that aside, as long as you pay them a sufficient amount, you end up paying like $10 per unit up to a certain number, which is fairly low. But state law and federal law, assuming that it's not a resident janitor exception, and that doesn't apply in federal law anyway, they have to be salaried of a sufficient level. That's the first thing, meaning no deductions for partial day absences except pursuant to a bona fide paid time and attendance policy. And then they have to have either an exemption as an executive, an administrator, professional, there's some other ones. Chances are
Outside sales, probably
yeah, right.
not that.
It's unlikely that they're going to fit any of those criteria if it's a one-person building, unless the superintendent is simply the conductor of all things, and there's a service that comes and takes the trash, and a service that comes and washes the floors, and the service that comes and fixes all the leaks, because the chances are he's not an executive or administrative employee. The manual labor criteria of a working superintendent will usually defeat the exemption.
Got it. All right, can that building charge the super rent for their apartment?
In the absence of an agreement to the contrary, the answer is yes. That will create a tenancy, most likely. And that's where you're going to rely on your housing court professional to tell you whether that is more than what we just discussed, like a preferential rent, maybe he's a mere licensee and you have a license agreement, not a lease. I know all these words. I don't know what any of, I do know what they mean, but I don't know enough to speak beyond giving you the catchphrases and say, talk to somebody who actually knows what they're talking about in this area. But it does open up housing type issues. But yeah, if you got a contract that says I'm giving you a free apartment so you live in, yeah, you violate your contract. Contracts apply. So a union contract usually says resident employees shall be provided a rent-free apartment with reasonable utilities. Don't violate your contracts.
Right. And one main thing to clarify is that for budgeting purposes, they don't need to start factoring this in until at least April 1st as the worst case scenario, right? Not this January.
Yeah, no, January is off the table. It's the state fiscal year, April 1, 2020.
Right.
The only thing I can add to that, just to
Yeah.
throw it out for discussion, is boards may want to look at the full effect of what a year of the prevailing wage might look like. So possibly looking at what it looks like from January 1st through December might be a good exercise to see if you really are trying to compare if it's worth it to compare versus the abatement. It might make sense to at least look at the figures from January 1st on.
Guys. So I always like to finish it off with just one word of wisdom or a sentence. If you guys could each just let us know, because this, obviously is a moving target. It doesn't seem to be a firm date, just it's looming. So I guess, Robert, do you want to start and everyone else follow?
Sure, happy to start. It's a complex area, pay attention. Doing it wrong is very expensive, but this may be the state's move to eliminate all these abatements and not a union organizing measure.
Okay, I'm going to go with do not forget the supplemental benefit rate. That don't, just because you have the hourly wage rate figured out correctly, please don't forget the key component of this, or one of the key components, which is the supplemental benefit rate. That'll save you a lot. $13.71 an hour right now, that is, but figured out up to 40 hours per week. Do not forget it. Do not ignore it.
Good advice. And Meagan?
Yeah, I think it's just being prepared, talking to your professionals, making sure you've done the calculations and weighing your options.
Isn't this budget season?
Yes, it is. It's a great time to discuss it. From what I understand, you have until April to sign an affidavit saying you've complied. I don't know how they're going to administer all of these affidavits, but it's a good time to get the conversation started while you have a few months to work it out.
Great. Well, this was great advice from all of you. We really appreciate your time tonight. Thank you, Robert, Sarah, and Meagan. Again, here's all of our information. We'll be circulating this tonight after our roundtable, so you'll have everyone's information to be able to reach out to. And as usual, thank you so much for joining us. We hope this was informative. All right. Have a great night, everyone. Thank you. Bye.
Thank you.